on Schedule B. So this electronic filing system is going to do more than enable us to file cheaply and quickly. It's going to enable you to keep track of the cases. They don't fall on the cracks. If I want to find out a case that has had no activity in X number of days or years, I punch a button, I can find out that list. And this filing system presents statistical data on the judges. It makes it open. It very, everyone can see what's going on. Everyone understands exactly what a particular judge is doing, how industrious he is. So I believe I'm able to take that type of filing system, that type of experience to the circuit court. And may I just say, for practicing in workers' comp, for practicing in dependency court, there's a big similarity there, and that is that these cases are handled in piecemeal litigation. They're cases that you see frequently over and over again. A workers' comp case does not go away unless the parties reach a total settlement. So I have cases in my office that are over 10 years old, over 20 years old, that I must look at on a regular basis, very similar to a dependency court. You might be looking at a case at a shelter hearing, then later on in a pendency, and then multiple review hearings. All the time the judge is diaring the system, keeping track of the issues, keeping track of the parties as they come and go. And that's very similar to what I do as a workers' compensation judge. So again, I'm very excited about this position. It means a lot to me and my family. And if you have any questions, I'd be happy to answer. And again, I want to thank you very much for your attention today.
Judge, if I could pick up your demeanor and the things you said were important to you, fairness, politeness, courtesy, and take that back with me to circuit civil, I would just be the happiest. But how would you take charge of a dependency courtroom where there are many people yelling and highly charged? How would you handle a criminal system where you have angry or mocking defendants in your courtroom? How would you take charge of a courtroom like that?
Well, let me just say that unfortunately we do experience quite a bit of that in workers' comp. I do have a lot of emotionally charged litigants right now. I have a lot of pro se litigants right now. I have a lot of people who have emotional problems, very angry. We have security issues as well. And I have attorneys that are unprofessional many times. So those are all matters that I deal with right now. And you know, that's a great question, because particularly one of the differences between a JCC and Article 5 is I don't have contempt power now. So I'm sort of charged in doing that right now without the power to hold or threaten contempt to individuals, which is, I guess, something that the Article 5 judge could eventually do. One way you do it is by setting an example in your demeanor, example with your voice, a very logical, very honest approach to the attorneys, to the parties. What will happen if they go down this line? I cannot understand what you're trying to say. If you feel your case is so important, you're going to have to change your way you're presenting it, because I'm not following what you're arguing right now. There are sanctions, there's penalties that I use now, such as attorney's fees or costs, striking claims, striking defenses. There is, you know, I don't use my gavel, but I have the gavel there at all times, because I think it's been the approach, the patience, allowing a person, calling them Mr. So-and-so, Miss so-and-so, being polite, letting them know they're going to have their say at a particular amount of time, that they need to be patient. And when we get to that time, I'll give you every opportunity that you have at this point. So there are a lot of things that you can do. There are pre-trial procedures, there are continuances, there's let's go ahead with the court, with the file, or with the case right now. It all depends upon the situation and on the people, but it's been my experience, though, if you give them the feeling that they can trust that they will get their argument out and they will get their position, and that you will be quiet and allow them to make their argument, for the most part, absent some severe mental illness, they're going to eventually fall in line. Although it does take an amount of time, but it does rely on an example. If I were to lose my temper, if I were to scream and holler, I don't think I would be able to maintain the decorum as much as you do by setting an example. I think professionalism is the way to go. It engenders efficiency. It allows the parties to see an example of what type of behavior is expected of them. And the same thing from the attorneys. And I tell the attorneys, what do you do when you have an attorney against you who is unprofessional? How do you handle that? And the answer to that is by really turning up the professionalism level of yourself, really being professional towards that individual and being fair. And for the most part, it does work.
Tom, I think that you might be a little bit modest on the bar survey. Not only were you highly ranked, but I think if you compared yourself to all of the others, you were either the top or very close to the top of all of the compensation judges, from what I could tell from the graph. Is that an accurate portrayal?
Yes, and I've been ranked similarly for many years now, maybe 5, 6 years.
And you're a one-judge office. So you are the chief judge, you are in charge of the court office, you have to deal with all the staffing issues, you have to do everything in your office by yourself. Is that right?
That is correct.
And those orders that you submitted and all of the orders that you've done, you write them yourself as well too.
That's correct.
And I understand that you're among the leaders in the compensation courts in getting your orders out in a fast and efficient manner.
Yes, I try to work on them immediately.
And I think, as is evident by your work product that you did place in here from your orders, that and I vetted you, so that's why I know a little bit more about this and paid attention to it, and by the people that I've talked to, when you write those orders, it's whether the person wins or loses, they understand, because you incorporate the facts and what transpired in order to obtain your conclusion in your orders, so that all sides will understand whether they won or they lost, where you came from and why you did it. I know I'm kind of stating, but I'm just kind of trying to bring out some things in your application, because it was a large application, and I don't know whether everyone was able to get to all of the substance in your application, so I wanted to highlight some of the things that I saw. Let's see. Anybody else? Go ahead.
Well, I noticed you,
I don't mean to monopolize.
you've conducted a seminar on judicial order writing and litigation management.
Yes, sir.
Can you tell us about that a little bit?
Well, the seminar is to other judges, and we discuss writing skills, maybe a big picture from your order. What will it look like, so that the reader can easily follow. And I do sometimes write for the litigants, including a pro se litigant, so they can understand, and it does remove any animosity they might have towards the court when they understand, when they see the case law precedent there. So one thing is the organization of your order. What are the issues? Put it in a way that's simple for the reader to follow, so he knows that we're talking about this, oh, now we're talking about this, now we're talking about that. Very short and simple sentences is something I try to use. I try to avoid legalese unless I need to actually use certain Latin terms that have significance. Other than that, I try to make very short, simple sentences, and organization is really the key for me for order writing. Knowing what comes where, what issue I'm working on, not to get confused or mixed up. I've seen attorneys submit proposed orders in the past, and that often is the biggest problem. Things seem to be split up and not well organized. We also talk about how to handle a case, whether to consolidate cases, whether to bifurcate issues, whether to voluntarily recuse yourself under certain situations, how to work with the computer electronic filing system, case management system, how to schedule your motion hearings. That's a big thing. Sometimes you have a lot of motion hearings, and you have to know whether you're going to use like a cattle call method, or you're going to have scheduled times for motion hearings. Then we have evidentiary motion hearings as well, which aren't big full-blown trials, but will take several hours of presentation of evidence, and those need to be scheduled appropriately. And you, not only how much time on your calendar, but when on your calendar to put them? How long before the parties are going to be ready to try this case? So it might involve having pretrial conferences or informal telephone conferences with the attorneys to find out how much discovery is going on, how many witnesses are going to be, what's the status of this case. And I like to use motion hearings or any opportunity that I have to look at the big picture of the case. Where are we going with this case? What do I need to do as a judge to try this case most efficiently? What type of schedule, what type of time do I need to make available, and when? So these are things that I would cover in a lecture that talks about case management, how many cases you're having, which staff member is handling what task. In my office, we try to cross-train. So I mainly will have one lady doing one task and another lady doing another task. But if they're not there, if they miss some time, they have to be cross-trained, ready to go. And that's one way you keep things moving very efficiently, and you don't lose these cases, lose track of the cases. So actually, that's a big topic. It could go on for quite some time. There's so many procedural issues. And the time I have for the interview is not nearly enough. So I try to include in my application on page 36, there's an essay of what you can bring to the position. And I just wrote a list. You see, I itemized a list of various issues that I've dealt with as a JCC, including procedural issues like that, substantive issues that a circuit judge might see. And I just listed them so you can see some of the things that I have dealt with on a regular basis, particularly if you're not familiar with what a common judge does.
Any other questions? Judge, thank you.
Thank you.
Thank you.